When parties enter into a contract for a construction project, whether it's between the architect and owner or the owner and the contractor, it's important for the parties to consider how disputes are going to get resolved. If the contract says nothing about dispute resolution, you're going to wind up in court and a judge is going to decide your dispute. But there are other ways to resolve problems between the parties. I'm going to talk about two of those ways. One is mediation and the other is arbitration. Now, when a dispute first arises, the best thing to do, obviously, is for the parties to have a discussion and try to resolve the dispute amongst themselves. Sometimes they can't do that. So the first thing they might consider, and have this in the contract, is mediation. If mediation doesn't work, arbitration is the alternative. So what's the difference between mediation and arbitration? Arbitration is a way of resolving a dispute by having an arbitrator make a binding decision. Mediation, on the other hand, is more like a negotiation. So the parties settle the dispute with the help of a mediator. So mediation is a way to resolve a dispute in a much more friendly and non-adversarial way. And hopefully the dispute is resolved in a way that the parties can continue on with the project or future projects. Sometimes that doesn't work, and you really need the help of an arbitrator to decide that dispute, much the way a judge might decide to might make that decision. So what's the difference between court, where a judge decides it, and arbitration, where the arbitrator decides it? Well, if you go to court, you don't necessarily have the opportunity to decide who your judge is going to be. And typically judges are not very familiar with construction, how it works, and are not really well versed in the ins and outs of construction, design, and so forth. Whereas in arbitration, you actually have a chance to pick an experienced construction arbitrator, somebody who's in the industry either as a professional architect or contractor, or more typically an attorney that does a lot of construction litigation. So they're familiar with the process. They don't have to be taught to what these various things are that are involved in construction. And it's a much more efficient and hopefully better way to get a real decision that works for the parties. So the two concepts are arbitration and mediation, and you can actually have both of those in the same contract. That's what the American Institute of Architects does. A dispute arises, the parties can't settle it amongst themselves. You go to mediation. You bring in a professional mediator, and the parties try to resolve it through that mediator, with that mediator's help. It's not binding, so if one of the parties is not satisfied with the way it's going, it doesn't have to conclude with a resolution of the dispute. But usually the dispute is resolved in mediation. If the mediation fails, then the next step is binding arbitration, where the arbitrator does in fact make a binding decision. You can have mediation without arbitration, so if you don't settle in mediation, you wind up in court. But often arbitration is the better way to resolve the dispute. So when you do your contract, think about how a potential dispute is going to be resolved. Do you want to wind up in court? Do you want to wind up in front of a professional, a trained arbitrator that actually has experience in these types of disputes?